Namaste ji, namaste. Welcome to Courtroom. My name is Sahaj. I sincerely hope that you're doing well. Today, let us take a look at the Bharaitya Nyaya Sanhita and how it pretty much is very old wine in a very new bottle. So 80 to 85% of the act, rather IPC, the code is pretty much the same going forward. The word code will soon be history, and instead of code you'll be using the word Sanhita, and instead of act you'll be using the word adhiniyam if things go as per the government's plan. So the Bharatiya Nyaya Sanhita 2023, we'll just have a look as to is it really different. So this is going to be a series of lectures on this channel. We are going to be first today analyzing the IPC from a very broader point of view, from a very macro overview, and then we'll get into the lecture in which I am going to do a dedicated lecture on the new sections, the brand new sections that didn't used to exist in IPC 1860. Then we'll go to the CRPC, and then we'll go to the Evidence Act. And evidence Kendra, they have done a decent number of very good changes, which warrant a discussion, but usually that is only touched upon by practicing lawyers, or if you are a judiciary aspirant, then those lectures become useful for you. So without taking much more of your time, let's go here. Once, if you're familiar with the IPC 1860, as soon as you open this bill, the first thing that you will notice is that chapter 2 is different. So if we compare it from IPC 1860, at chapter 2 it used to be general explanation. Now where have these folks, as in sections, where have these folks gone? So they are here. They have been clubbed under section 2, and section 3 runs parallel to section 6. So it's just a lot of reorganization and a lot of reshuffling. Critics of these bills will point out that what is the point of doing this? Well, we are not going to get into those discussions. How do you feel about these changes? Let us know in the comments below. Would love to hear feedback from students and lawyers alike. If you see this entire chapter, this entire chapter has been clubbed into section 2. Now if we go here, let us have a look at section 2. So all of your standard definitions, court, death, dishonestly, document, etc., it's all under subsections, different subsections of 2 only. So have they really reduced the number of sections from 511 to, let us say, 356 as what they claim? Not really. It is just a lot of reorganization, a lot of repackaging, you can say. A lot of repackaging. Alright. Now, if we see section 4 and section 5, so if you go to section 1 of the new bill and you compare that with आपका section 3 and 4 of the older code, the IPC, you're going to find that, well, they are the same. It is pretty much all of it is the same. If you see, all of this is the same, and section 2 again is, well, all of it is also the same, right? So यहाँ पर if you see this is absolutely the same. Alright, so it's just reorganization and reshuffling. It's nothing much more. So as a student of law, you're worried that your so much of your hard work is down the drain. It is not. It is absolutely not, because the section remains the same. The case laws will remain the same. It is just that the numbers are going to change. So the number of sections, as in, let us say that like for example 307, 302, they change. The section number is going to change. So if you're preparing for Judiciary 205, it is prudent to prepare criminal law last May and to rote learn the section numbers for your pre later, at a later stage. Right now just focus on the concept. So the concept of attempt remains the same. Everything remains the same. Mostly it is just the same. Alright. Now when we come here, you can see section 2 of course contains the older set of definitions. But you have newer explanations as well that weren't there in IPC 1860, such as transgender shall have this meaning assigned to in clause K of section 2 of the Transgender Person Protection of Rights Act 2019. Alright. Stuff such as, well, mental illness shall have the meaning assigned to in Section 2 of Mental Health Care Act 2017. And you will note that there are no citations, so there won't be footnotes, at least at the very beginning when this code gets notified, because all of the amendments have now been incorporated. So what do I mean by that? What do I mean by that is 228A, for example, is somewhere around section 72 of this act, 228A. Now, what was the meaning of that A? A used to be that the section has come in via an amendment because they didn't want to disturb the chronology of the act. But now, since they're rewriting it, so they have reorganized it. All right. Now, if you take a look at section 3 of this act, now section 3 of this bill, वो बोलते बोलते it's just layman language में just Sanhita, then act, and then bill will get overlapped. But section 3 says, well, everything is subject to general exceptions. Great, that used to be section 6 in the older act. That used to be section 6 in the older act, and we always used to say chapter 4 general exception, section 76 to 106 read with section 6 of the IPC, and then if you wanted to get more marks you used to mention section 105 of the Indian Evidence Act. All of those ratta tricks are now down the drain. The concept, however, it's the same. Okay, so the parallel of 6 is, well, 3 in the older act. And now if you see 34, 35, 36, 34 has been in service of the police and every other prosecuting agency, investigating agency or whatever in the country for decades, but now 34 has been given the status of a subsection in I believe in section 3 itself. So section 3 subsection 5 is 34 because, well, everything used to be read with 34. Every time IPC comes into operation, most of the sections are read with 34. Most of the charge sheets used to contain this. But now बेचारे की थोड़ी इज्जत कम कर दी गई है, थोड़ी उनकी इज्जत में कमी करके we have given them, or we've given आपके this section 34 को हमने यहाँ पे club out करा दिया. But when you look at certain explanations, for example, now this is a good one that they've added. When property is in possession of a person's spouse, clerk, or servant on account of that person, it is in that person's possession within the meaning of this Sanhita. These explanations from based on law commission reports, they are very decently done. It's just that this bill requires a lot of proofreading. I really don't know who I really don't know whether they double checked it or not, but this is how things work in Sarkari departments. This is a new clause, the new kind of punishment. So in chapter 2 of punishments in the new bill, and in the older code, chapter 3 of punishments, right? Section 53 used to be for punishments. So death gets repeated, great. Imprisonment for life again gets repeated. Now if you notice these things, these citation notes that you used to refer to in footnotes as to where all were they coming from, which amendments, they are missing because, well, they were rewriting it, so they have rewritten it very properly. Community service is a new addition. It didn't used to exist back in section 53 of the IPC. It didn't used to exist. So this is a new one, and therefore it is a short MCQ. This is a short MCQ. Whether you're taking the CLAT PG this year, buddy, community service के ऊपर आ सकता है that the government has proposed what kind of punishment, right? And अगले साल की judiciary pre में अगर तब तक ये notify हो गई, such questions can definitely pop up, and from 2025 onwards तो यही काम करना पड़ेगा, right? Now when you go to chapter 3 general exceptions of the newer bill, you will find that it has everything as it exists right now in your present day IPC. That is 30 sections, so 76 to 106. This is going from 14 to 44. I have taken a cursory look at it. I really haven't found any differences whatsoever here. So that one chapter 2 has merged into section 2, and therefore niche wale chapters have gotten a promotion. That is just what the change really is. And since the statement of objection reasons for this bill contained that they wanted to give precedence, or rather you can say they wanted to give it some sort of priority of offences against women and children. So from the 370 odd ranges, they have put in those offences in the section 50 to 60 to 70 odd ranges, so that they chronologically appear before any other offence in this in the new IPC. Alright. Now if you compare आपके chapter 4 of the newer one of abatement, it is pretty much the same thing. But if you notice here, as our attempt very popular section used to be there for 511, it was pretty much everyone's favorite and a very very simple section. But यहाँ पे अगर आप आते हैं of attempt, you will see that it is now section 62. So it has been just copied pasted word to word. I'll show it to you. 511 is now become 62, and that is pretty much the overall flavor of this change. Just that 511 is going to 62. Wherever code is, it will be replaced by the word Sanhita. That's just all that there is to it. I mean, it's nothing much more, right? And certain sections are there which are well, very much need of the hour, and the government has played out its cards very very carefully. They haven't really mentioned anything controversial up till now, and they are introducing these sections. So for example, now if we go into section 63 of rape, used to be 375 in the older code, वो सारे वो जो जुबान पे जो रटे हुए हैं, like for example from CRPC 482, 154, 41, all of the classic sections जो रटे हुए हैं सबको, they will all will have to be rewrote, learned again. That's just what life really is. Nothing really is permanent. This is merely a bare act. Everything changes. It changed in Companies Act 2013, I believe, on the 29th of August 2013. That act came into operation. That time corporate lawyers bore the brunt. I believe that अब यहाँ पे वही दोबारा रट्टे ही मारने पड़ेंगे और कुछ है नहीं. Now if you see exception 2 of section 63, it says sexual intercourse or sexual acts by a man with his own wife, the wife not being under 18 years of age, is not rape. Now this is an implementation of the judgment of Independent Thought versus Union of India 2017, because if you go to the older act, or rather the older IPC, older code, you will see sexual intercourse or sexual acts by a man with his own wife, the wife not being 15 years of age, is not rape. यहाँ पे 15 लिखा है, वहाँ पे 18 लिखा है. Legislature has not done anything on its own accord. There was a judgment in 2017, and they have just implemented the decision, because we also used to learn that this is now 18. But why didn't it reflect in the act? Because they never really amended it post that judgment. And 2018 criminal law amendment आई थी, but they never really touched it. They should have changed it, but now they have. Alright, so there are certain implementations of classic criminal case laws relating to the IPC. For example, adultery now doesn't feature in this new bill, but however, a dedicated section of section 65 does. Very similar to 376 AB, but that was specifically for gang rape. So for example, whoever commits rape on a woman under 12 years of age shall be punished with rigorous imprisonment, for which shall not be less than 20 years. Now this is very decent. This is good work by the government. And again, under 16 also shall not be less than 20 years. So similar parallel sections exist in the older code as well, like I've told you for 376 AB. But I believe those were for gang rape, and now this is for rape as well. And they say that they have made laws gender neutral. Yes, some have. Whoever, not only a man, whoever, all right, may just get interpreted that way. Section 69, they just had to make it 69, didn't they? Whoever by deceitful means or making by promise to marry a woman without any intention of fulfilling the same, and I believe this and is unnecessary here, has sexual intercourse with her, such sexual intercourse, basically this is deceitful means, and then false promise. Whoever by deceitful means, this you can say that people conceal their identity and then end up marrying the woman, or not marrying the woman, has sexual intercourse, actually not marrying the woman, just making a promise, and has sexual intercourse with her. Well, that has been made into an offense. So that is section 69. If you go to 72, 72 is just a parallel of 228A. So we are going to do a dedicated lecture on offenses. This is a brand new offense. Section 69 is a brand new offense. But 72 and 228A, you need not even read it. I mean, it's pretty much the same thing. Even the punishment hasn't changed. If you're preparing for judiciary pre, if they have changed any punishments, you will need to make a table and well prepare accordingly, all right? Because you'll need to track whether they have changed any punishments or not. Okay. Now, if you go here and you go to आपके again all of your the sections which were placed in the 400 odd ranges, they have now been placed somewhere around 82, 83, 84. So if you go here and you see 82 is the exact parallel of 496, 83 is the exact parallel of well 498, but 497 is missing. Well, 497 is missing because of Joseph Shine, all right, because of that judgment. And that's pretty much it. If you go into murder and culpable homicide from 299, now we are into the 98, 99 wali range. And everything is just copied, pasted. It's, you need not worry. Has anything really changed? No. No. Except for a certain few brand new offenses. It is just reshuffling and renaming the sections. There's nothing much more to it. एंड जो नए ऑफेंस ऑफ कोर्स यहाँ पे आईपीसी में आएंगे, जो न्यू आईपीसी, their relevant provisions will be introduced in the CRPC. CRPC में some interesting changes have been made, such as the definition of bail has been given. We'll need to do one session on the changes in the law of bail that they're proposing right now in the CRPC, and then evidence में some very good changes have been done. But we'll see how do courts interpret those changes in the upcoming times. Very interesting times ahead, given the change that they have done. So that ends it for today. IPC में ज़्यादा कुछ change नहीं है. No need to worry. No need to throw your old textbooks. The case laws are the same. The interpretation will be the same. The ratios will be the same. It's just that the section numbers are being shuffled around. Nothing much more in the IPC, at least, except again वही वाले जो couple of offences. Nothing more. All right. On that note, no need to worry at all, and these are just cosmetic changes in my opinion. In the next lecture, let us discuss about the brand new offences under the IPC that they have introduced. Then we go to the CRPC, then we go to the evidence, and that's about it. Wishing you all the very best. Very old wine in a new bottle. Take care. Bye.